Welcome, and thank you for joining us today for part one of our series on jury trials in 2024, presented by Seyfarth's Employment Trial Team, featuring lessons from the front lines. This installment of the series will focus on trying cases in a polarized environment. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature on WebEx. However, if your question is not answered, our presenters will follow up with you directly in the coming days. For those of you interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down as it will not be repeated and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Dawn Soloway, Lynn Kappelman, and Claire Luna.
Thanks so much, Andy. It's great to be with everyone this afternoon. My name is Dawn Soloway, and I'm a partner in Seyfarth's Boston office in the Labor and Employment Group. I'm a member of our national trial team and a co-lead of our national appellate team, as well as a founding member of our Cultural Flashpoints Task Force, which helps employers navigate polarization in the workplace.
Good morning. My name is Lynn Kappelman, and I am a partner in Seyfarth's Boston office. I like to say that my desk sits in Boston, but my rear end is rarely in that chair because I co-chair Seyfarth's national trial team. So I really am traveling all over the country working on trials in state and federal courts as well as arbitrations.
Hi, everyone. I'm Claire Luna. I'm based out of Orange County, California. I'm the managing partner of Jury Impact, a jury consulting firm that's been working with Seyfarth for about 16 of the 19 years I've been with this company. Looking forward to today. Thank you.
Next slide. So today we're going to be talking about the trend toward explosive verdicts. Many of us have been watching the headlines where more and more juries are handing down nuclear or explosive verdicts, even in single plaintiff cases. And we're going to talk about some of the trends that are driving that increase in explosive verdicts. We're also going to talk about how juries don't necessarily agree with what the law says or what the jury instructions say. And then we're going to talk in more detail about how to connect with the modern juror in 2024 in our polarized environment. Next slide. So first we want to spend a moment on the trend toward explosive verdicts. Next slide. Large verdicts are getting more common, including explosive verdicts that are irrational and seem totally disproportionate to either the facts that are in evidence or the law that the jury is being instructed on. And correspondingly, we're seeing what we call explosive settlements or explosive settlement demands, where plaintiffs are sure that they are going to get the next nuclear verdict and are therefore insisting on a settlement that is wildly disproportionate to the actual evidence in a case. And this is sort of a vicious cycle because these verdicts tend to get normalized. They get reported in the media, and then they become part of sort of the cultural landscape. And so when those next jurors go into the jury box, they are already familiar with the fact that these multi-million-dollar verdicts have become more common. Next slide. So, we think a lot here in the Seyfarth trial team about the new jury and how some of the trial strategies that worked maybe even 5 years ago are really no longer relevant. And here are a couple of the reasons why. One is that people are still so raw from COVID, from the disruptions of the COVID era, the fear that drove so much of that era, and the divisions that arose during that era about, for example, lockdowns and vaccines and other cultural flashpoints. Increased prejudice against the other, whoever that might be, depending on which group you're in, and a stronger sort of tribalism between people who are of the same or similar background. We know from the science that in times of stress, people are prone to more intuitive instead of logical processing. So people are kind of already kind of geared up to deliver, a more irrational or emotional response. We are, as a country, increasingly polarized. You need only open, the New York Times today to see how so many cultural divisions are just all over the headlines. And we know that there is anti-corporate sentiment in both major political parties. And that, of course, makes it a trying time for employers in jury trials. Next slide, please. And I think Claire is going to show us some examples of this from her work with mock juries.
So this is the first of several collections of video clips from actual focus groups we've done in the past 3.5 years. Many of them have been with your firm all around the country. I think we have today Seattle, Southern California, Chicago, the Bay Area, Minneapolis, and even just as recently as 2 weeks ago in Kansas City, groups that we did with your firm. We started doing virtual focus groups in April 2020, but we were back to doing in-person by June 2020. So very, very early in states that had different perspectives on COVID than, say, California. But these clips show that anti-corporate sentiment that Dawn was talking about. People are, frankly, tired of working for corporations, shopping at corporations. And so you see a lot of these negative feelings permeating a lot of our clients, who tend to be big box stores, national restaurant chains, international tech companies. And so there's this growing anti-corporate sentiment that's you'll hear some of this in here. There's a feeling that big business just takes lawsuits and litigation costs as part of, the cost of doing business, and jurors have to hold them responsible as a result. Go ahead and play the clips, please.
You're factoring in this is a big company.
Yeah, they sell billions and billions.
Sure.
100 million is a rounding error.
It's nothing for them?
So nothing.
So on a larger scale, I'd be curious to know how frequently deals with these kinds of suits and how they reach an outcome. Like, is it a business practice just to do it and be like, we made $4.2 billion, they're gonna sue us for $5 million, whatever.
Right.
If they have a threshold that part of their business practice is, we're gonna lose X amount when we inevitably get sued for this, and that's fine.
Wow.
Because that changes the whole idea. It's like, yeah, this is the underdog by hundreds of billions of dollars or whatever. Are they just doing that to everybody?
Behavior of a multinational tens of billion dollar corporation.
It seems like most of these companies just want to blow off problems instead of addressing them because it's easier.
Andrew, you gave it a 4 on the lower side. What's that based on?
I just don't, I'm not big on corporate America.
And I think one of the things to look at with all of these clips is a big difference from where we were 5, 6, 7 years ago when I was going around the country talking a lot about millennial jurors and how awful they were. We are now seeing some of these troubling, challenging perspectives, jurors all across the age spectrum, all different ethnicities, all different political backgrounds, education backgrounds, and you're seeing all of these challenging sentiments expressed by an entire swath of America when before it was just isolated to certain groups. Dawn will talk about some of that social movements.
Next slide, please.
You're factoring in this is.
So another trend that is driving explosive verdicts are some of the social movements that are so salient in our society today. So the Me Too movement, of course, has fundamentally shifted the way that people understand claims of gender discrimination, pay equity, sexual harassment. The Black Lives Matter movement has been very influential in the way that jurors think about, for example, the distrust of police, which is also part of a general trend of less trust in institutions. Concerns about income inequality can really help spur jurors to want to level the playing field against employers, particularly if they're large corporations. Quiet quitting is a contributor, the way that it's sort of celebrated in parts of the culture for someone to kind of phone in a poor performance, rather than considering that to be something that's problematic. And then the cultural conversation about pay equity also leads many jurors to be suspicious of employers around anything having to do with gender or pay. Next slide, please. I This is a graph that shows what we've been talking about in terms of the loss of trust in institutions. So the average share of Americans who have a great deal or quite a lot of confidence in various institutions that Gallup has consistently asked about since 1979. And you can see in the graph how that number has fallen over time. And now Lynn is going to talk about how jurors don't necessarily agree with what the jury instructions say.
So one of the things that I see quite often, and I will call it, quote, a rookie mistake. A rookie mistake is saying, well, here were my fabulous arguments on summary judgment about what the law says, and I'm just going to make those same arguments to the jurors, and they're going to adopt it. Let me just say this, that trust me, your case will not rise and fall on the McDonnell-Douglas burden shifting standard, whatever the hell that is. The jurors are going to say, whatever the hell that is. Next slide. So we get very enamored with our summary judgment arguments when we make them. And when they don't win, we stay on that same road and we keep making the argument. Don't do it. Ladies and gentlemen, the jurors are going to be very skeptical of some of these legalese arguments. Perfect example is that we are wedded as companies and employers to this notion of at-will employment. And we can almost say the rap, which is, I can fire him at any time for any reason as long as it's not illegal. And then we figure, okay, well, then the jury's just going to buy that, end of story, fold up our tent, go home. The truth of the matter is, jurors are very skeptical of at-will employment. Next slide. And what they're going to look at, folks, are, did this employee have good performance reviews? For how long? Did they recently get a raise or a promotion? Were they there for 21 years without any problems, and then all of a sudden a new manager, a new sheriff in town thinks that they're not performing well? That's what jurors are going to look at, regardless of whether they're, quote, an at-will employee, and you can fire them at any time for any reason. There is a notion with jurors of fundamental fairness. Were you fair to this person? And fairness gets measured by how long were they there? What were you telling them while they were there? What kind of a job were they doing for you? Why did you give them a raise a year before you decided they needed to be performance managed out of the company? So be very aware of those kinds of things that may hurt you in front of a juror. Next slide, please. The other thing is, I was so enamored with the argument when I first started practicing. This guy wasn't mean to just women. He was mean to all the men that worked for him too. He had a potty mouth with the young people. He had a potty mouth with the old people. And so do you think the jurors are going to love him? No. The jurors are going to want to punish him just as much if they find out that he was mean to everybody as if they find out that he was just mean or just toxic to the person sitting on the witness stand suing him. So I would just caution you against this argument that the person who is sort of the perpetrator of all ills, there's always one in every case, is an equal opportunity jerk. It doesn't work. And to the extent that you're worried about punitive damages, it is that equal opportunity jerk who's going to get you in hot water. And we'll talk more about that later, sort of what drives these high verdicts. Next slide. Jurors love to see progressive discipline. And what do I mean by that? They want to know this. Did you tell the employee what they were doing wrong? Did you give them an opportunity to fix it? Did you give them a long enough opportunity to fix it? And then did you explain to them exactly what they would have needed to do to fix it before you took sort of whatever it was, the adverse employment action? For whatever reason, no matter what your policy says about progressive discipline, you may not have a progressive discipline policy, and quite often we get away from those policies. But jurors like to see fairness, and by fairness they mean, did you give somebody notice that they weren't performing and an opportunity to fix it? And so I will just say this, it's the first thing that people ask is, how did they know they weren't doing well? Did you give them a long enough time? And quite often where people get into trouble is, one, we didn't tell them they weren't doing a good job. In fact, we gave them a great performance evaluation last year, or it was a mediocre performance evaluation, but it wasn't poor. Two, we didn't give them long enough to turn it around. Or three, we didn't tell them exactly what our expectations were about how they could turn it around. So, even if you've ditched your progressive discipline policy, just realize that that's what jurors are looking for, this sort of fundamental fairness, notice, and an opportunity to cure. Next slide. And this we all know. I mean, jurors are skeptical about treating companies equally with sort of the individual. And we saw that in Claire's fabulous slide about people saying, well, they've got billions of dollars. They treat this as the cost of doing business. How do you address that, ladies and gentlemen? What you do is you give the company a face or faces. You make it clear that even the president of the company is a person. And one of the best ways to do that is by the person you pick to sit at council table with you representing the company. If you pick someone who is constantly looking like they're eating a rotten lemon, or frankly nasty to people out in the hall or in the ladies' room to sit with you at council table, that is going to be a reflection of the company. Whoever you pick should be someone who is a good reflection on the company to sit at the council table with you, and they need to be counseled that whenever they are in eye shot and earshot of the jury, they are a reflection of the company. And that means when they get out of their car in the parking lot at the courthouse, they don't know who's parked right next to them. When they're in the elevator coming up to the jury room, and when they're in the ladies' room, they are an embodiment and a reflection of the company, and they need to be that person. So personalize the company in the same way that the plaintiff's lawyers are personalizing the plaintiff. Next slide. So we're so lucky today to have Claire here, because she is gonna help us understand how to connect with the modern juror in 2024, which we have learned from Claire is very, very different than connecting with jurors in the past. Claire?
Thanks. And I will say we are, to I think all of our surprise, making absolutely fantastic time through this presentation. So please do use the Q&A feature to submit questions so that we can try to answer them as we go along or afterward if we do happen to run out of time. Next slide. And Andy, before you click, I'm going to direct you when to click, just because I'm normally used to running this myself, and so it's a little different. But we tell people, if you haven't done research since before the pandemic, and that includes focus groups, which we're a huge proponent of, mock trials, which we're less so, which I'll talk about in a little bit, but any type of research where you're talking to your jurors in your jurisdiction about what they think of your case. If you haven't done that research since before the pandemic, click your data's outdated, click your numbers are skewed, and click you don't know your jury. A perfect example of that is a case that we worked on for a healthcare client. It went to trial last year. Our client in Florida was hit for $48 million. Afterward, they called and said, we want to interview the jurors, but we're confused. We did focus groups for this case, and it said this was defensible. What happened? And I looked back at our report because I was concerned too, and I said, we did that research back in 2016, and a lot of the facts of this case hit very differently now than they did back then. For example, this involved a Black mother who had a baby that suffered a birth injury. It involved conspiracy theories and allegations of cover-up. Just overall, that we'll talk about in a second, is more distrust in everyone, including healthcare providers. So all of those facts hit very differently back in 2016 than they do now. And here, click again. Back in 2016, when we did those focus groups, I was pregnant. That child is now 7. So believe me, I'm not just including my cute, adorable kid for no reason, but it shows this is how much time has passed since some of these clients that we have done research. You cannot just apply your pre-pandemic research to today and think that it's going to be accurate. Next slide. So, Dawn talked about this pretty well, and I just want to add, talking about what has shaped today's jurors, a lot of those factors that she mentioned, and there's this underpinning of anger. We ask everyone in our focus groups, do you think America is on the right track or the wrong track? Before the pandemic, it was about 50-50. Since the pandemic, especially in the past 2 years, we've looked at this data, it's 90% of our focus group jurors believe America is on the wrong track. They're angry, they're disenfranchised, they don't trust anyone. And again, that's a number where it's broad, it's covering everyone, not just certain people. So you need to be thinking about that. That polarization is also really key too. Dawn and Lynn are more sophisticated, so they talk about opening the New York Times. I talk about opening the Peloton Moms group on Facebook. You can see the polarization there when people are arguing about literally everything under the sun. I don't need to list them, but homeschool, for example, everything just becomes this back and forth debate. Everyone is angry at each other, and you see that played out in focus groups and in actual jury rooms throughout America. Next slide. The distrust, the crisis of confidence, is also an incredibly important factor to think about. That distrust, again, is covering all ends of the political, education, race spectrum. And the numbers that we're seeing today are very different than they were a few years ago. That picture on the top is me back in 2001 when I was interning at the Fort Myers News Press, when trust in media was about 67%. Now trust has plummeted to half of that. So no one can believe anything that they're reading. People are only reading the things that they trust, which of course is echoing what they already think and becoming that situation. People don't trust corporations. That's no surprise. People also don't trust the government. Why is that important? Sometimes we're relying on government investigations and hoping that that helps our side of the case. And when people don't trust the government, law enforcement, et cetera, we can't rely on that anymore. There was a case we worked on in Connecticut for a big healthcare provider where a nurse was stealing fentanyl. And there was a government investigation that found that it only covered a certain specific amount of time. And so we said that the damages should be limited as a result. Well, the problem is no one trusted that government investigation. They said it probably started way before and way after, and there's been a cover up. Talking about conspiracy theorists, many, many more of those than there used to be. 20% of America essentially believe that Taylor Swift is involved in a covert effort to help Biden win the next election. I also saw a statistic recently, 10% of Americans believe the earth is flat. And I know it's easy to dismiss that and say, oh, it's only 10%. Well, I was flying back from Missouri last night. I stopped in Denver. It was packed. There were hundreds of people in my little train car between the terminals. If you think about that 10%, there's probably 30 people in that train car that believe the earth is flat. So it's a lot more prevalent than you would think. And then that trust also includes reluctance to accept anything at face value. Because of AI and even Instagram filters, no one trusts anything they see or read. If you see a picture of someone, you assume that's probably been filtered. And if you hear an expert in court, you assume they have some bias too, simply because of who they're being paid by. Next slide. These are some of the things that we ask all of our focus group participants. And I will say the numbers before the pandemic weren't great either, but they've gotten even worse. And I think all of this again shows that the defense oftentimes has an uphill battle with jurors coming into a courtroom already giving the plaintiff the advantage. A significant number of people, and growing, think that if a case gets to the courtroom setting, the plaintiff's case has at least some merit. Essentially, they think there's some mechanism out there to throw out frivolous lawsuits, which in some cases there is. Judges can throw out a case on summary judgment. So when jurors hear about that, they think, okay, if it's gotten to the point where we're here as jurors, then someone has decided it has merit. The idea that some people think filing a lawsuit is too hard, that number has significantly increased. That has been the number one predictor of plaintiff verdict, the answer to that question, in all of our focus groups for the 20 years I've been with the company. People who think it's too hard to file a lawsuit think there's inherent challenges in the justice system for the average person trying to get justice. As Lynn covered, people are more inclined to ignore jury instructions and decide a case based on what they think is right or what they think is fair. The idea that lack of trust again, and there's been a significant increase in people who don't trust the justice system. I think a lot of that is tied to the overturning of Roe v. Wade and just the entire idea that the system is broken, including standard of care, the justice system, et cetera, and jurors are here to fix it somehow. Next slide. Oh, Don,
You're on mute.
You're on mute, Don.
Sorry about that. I want to talk for a bit about a recent mock trial that we did out on the West Coast for a healthcare client. And it was really fascinating because the jurors spoke a lot about how much they had gone through during the COVID era. And I think Claire touched on this. But we heard from jurors who had family members who were healthcare workers, people who had the experience of not being able to visit a loved one in the hospital during lockdown, even when they had a serious illness or were giving birth to a baby, people who had caught a COVID infection in the hospital, people who had family who were afraid to go to the hospital during COVID, and of course, people who had family who had died of COVID. And so it's just, really a testament to how raw people still are from the pandemic. Even this was in early 2024. Also, jurors who wished for the employer to have done more. It was fascinating listening to them in this over this 10-hour period. Just repeatedly going back to well, I feel like the employer could have done more, and not necessarily really explaining what the employer could have done more, or identifying it with any particularity, but just a sense that the company could have done more. They talked about how they wished that the employer had tried to find a compromise, and they were kind of throwing out ideas of what else the employer could have done to help the plaintiff, things that the plaintiff hadn't even raised. Wasn't even part of the plaintiff's case, but where they just were kind of looking for ways that they felt that the employer had failed. And then finally, this was a case where the plaintiff actually had received some warnings about violation of certain policies. And the jurors didn't really like those either. They found that they said, quote, "They're a little bit rough." Another quote was, "They look so cold. They came across as a threat." One called those warnings damning. And one used a very colorful phrase to describe the person who had written the letters, and said that she wished that the defendant had put on that person to explain the warning letters. So I think it really spoke to this kind of generalized loss of trust in the company. And in particular, this was a healthcare company. And this kind of instinct that the jurors had to blame the employer, and to wish that they had done more.
And Dawn, if I could just jump on that for 1 minute, in the context of religious accommodation cases, religious discrimination cases, disability accommodation and disability discrimination cases, understand that that means that a jury is going to expect you to engage in the interactive process, even if you think that there's a preposterous claim of disability or preposterous claim for religious accommodation. Think about what you're hearing about jurors wanting employers to do more, and think about how important and persuasive it will be when you can say, here's what we did to engage in the interactive process and couldn't resolve this conflict. So I just throw that out there for those of you who are, turn your nose up at the interactive process, especially when plaintiff comes forth with what we think is sort of a silly religious or disability accommodation issue.
I think that's so true, and I think that it's really, to Claire's point, the importance of doing these mock jury sessions, because in this 10 hours we heard a lot of themes that came out of that mock that, again, were not things that the plaintiff had raised, and not things that we necessarily would have intuitively thought the jury was thinking about. But by listening to these people and sort of what more they thought we could have done, we were then able to layer that into our narrative about the case, that we were directly addressing, why didn't we do X, Y, or Z, and why were the actions that we did take reasonable. Next slide, please.
You can just click through this to get to the fourth. Perfect. Okay. So, we've touched on this a little bit, just the increase in these gigantic verdicts that are getting huge headlines in the media, and really unbelievable has become the new normal. We are seeing verdicts in the hundreds of millions of dollars, to the point where it's almost America has become immune to it. And I will say, before I scare everyone away, the defense is still winning the majority of trials. The problem is when they don't, some of the verdicts get to be this astronomical level that in turn are driving everything else higher. Plaintiff attorneys are able to say, hey, this is the new benchmark. This is what we're talking about in 2024 are these values. And they start the settlement negotiations from there versus how it used to be. Like we've talked about before, jurors are deciding the cases based on emotion and perceived credibility. And so those are driving numbers up too. It's not necessarily about whether they even like the actual plaintiff in the case. They're thinking about what does this case mean for our future, for our family, for maybe if my family member works there, that kind of thing. And we really think that fighting these big verdicts requires a much more proactive and early management and identification of claims that have that potential to turn nuclear, that have that potential to awaken something in jurors out there that says, okay, this is going to be our send a message type of verdict. Next slide. You know, when we're looking at predicting those big aberration verdicts, we see a lot of times our clients are not really honestly reviewing the case facts. They're sort of excusing a lot of things. They're saying, oh, we can explain that. We can explain that. Well, I can tell you, when you have to play basically whack-a-mole with all of your explanations, it's very, very problematic for jurors. They're focused on what the plaintiff's arguments are. And, you know, sometimes as the defense, we take our arguments from the motions for summary judgment and I can turn them into normal speak. But you know where I get some really good plaintiff arguments is from looking at media comments on coverage of a case, because how people boil it down in their language tends to be the best way of understanding what people are really going to think about it. And so having that realistic view of the case facts, of damages, of how that's all going to play out is really, really important. We just worked on a case for one of y'all, and there was a lot of documentation issues. We could point to some text that happened, but you know what we found out during our focus groups? Jurors don't like text. They do not like text in a workplace setting because they don't think it's professional. So yeah, you can have something in writing. It doesn't count if it's on text. Emails are okay, but we found out the hard way that texts don't really work. And then, you know, there's also the idea if there's crossfighting among defendants, jurors just throw up their hands and say, you know, we're just going to side with the plaintiff. We don't want to sort through all this stuff. Then any facts, and this has been, you know, a growing trend too, that support the defendants ignoring or dismissing plaintiff concerns or well-being. We've heard more and more in our focus groups, well, that corporation traumatized this employee by what they put them through, and therefore they deserve more money. And that may not even have been a claim in the case, that idea of trauma, but jurors are again going to make up things in their minds that suit their narrative and give out damages based on that. Next slide, please. I know I keep harping on this about, you know, the change in attitudes toward corporate America, but, you know, one of the questions that popped up was, you know, how do jurors feel about educational institutions like universities? We have seen more and more that universities and hospitals are getting painted with the same negative brush as the typical corporation. Jurors view any type of institution like that, you know, in the same negative light as a corporation, and more importantly, assume that especially the administrators and leaders are going to be doing what they can to support that institution versus supporting the employee or student or whoever it is. So, you know, these numbers show that, you know, you pretty much all defend corporations, so do I, but the idea that people are much more negative, they have much more negative impressions of the lawyers who defend corporations has tripled since before the pandemic. That's very significant. Next slide. Before the pandemic, people would at least pretend to be neutral. They were asked, you know, in a lawsuit between a person and a corporation, who would you lean toward? Before the pandemic, 60% said neither. I don't think that's actually accurate either, but that's what they said. But now they're not even pretending when they answer a survey. Now 57% say they would lean toward the individual. 11%, and that number's jumped too, say they would lean toward the corporation. Only 1 in 5 people say they would actually be neutral. Next slide. How jurors evaluate the egregiousness of an error. You know, this is a, you know, straight across to the right, but really when you're looking at the damages that we see in our focus groups, the more you get to the right, the higher it goes up exponentially. And these are some of the things that are really important to evaluate when you're looking at, you know, how jurors are going to evaluate your case. Are they seeing just a normal, simple human error here, I mean, that's bad. But when you get to egregious error or even worse, intent, that can definitely drive up damages as well. I don't know if Don or Lynn wanted to add something on that.
I just want to say that I love this slide of Claire's because I think it really just, gives employers a kind of a rubric to try to frame your case, right? That you want to keep in order to avoid an explosive verdict, you want to stay out of that red zone. And so even if that means that, you have to, depending on the facts, of course, but even if you have to admit that there was some, mistake in judgment, or worst case that something fell through the cracks, that is an entirely different thing from actually having the plaintiff establish, an evil motive or, some sort of egregious error. So I think it's a really important framing.
And trust that the plaintiffs are going to be doing the exact opposite, which is, even if there was some mistake, they are going to frame it as a bad motive or, even an egregious error. But you're always going to hear that so-and-so had a motive, and that was retaliatory. You often hear sort of retaliatory because someone complained or someone, made a comment that they didn't like. And so quite often plaintiffs know this as well. They will take a mistake and try to cast it as someone having a bad motive and an opportunity to retaliate against them.
I think this is really an opportunity too for motions in limine because some of the tactics that plaintiffs' counsel will use to try to get into that red zone and bad motive will be improper tactics. And so getting ahead of that with motions in limine that try to keep those kinds of arguments out to the extent that they're improper.
Next slide, please. So, I kind of boiled it down to some big key differences that we're seeing from the pre-pandemic juries to now. And by the way, I say pre-pandemic as a shorthand, as we talked about, there's been a lot more than COVID that happened, but that really has been a turning point for America. And really the key difference first is that jurors are going to redefine not just what's reasonable, but what the law is or should be. Again, jurors are looking at what they think is fair. That's been a factor for a very long time, especially in employment cases. But right now it seems to be one of the only parameters that jurors are using to evaluate whether they want to be for the plaintiff in defense. We ask jurors all the time, regardless of what the law says, do you think this company did right by this person? And we can have a very defense-oriented jury in a focus group, but if we have the majority saying they didn't do right by this person, they weren't fair, we still remain very concerned that in a trial setting, some sympathy or other factor would switch around those jurors. It's a lot easier sometimes to switch defense to plaintiff than it is to get those very dogmatic plaintiff jurors to switch over to defense. We're seeing that idea that, something might have changed the outcome, could have changed the outcome. That's the new standard. It's not, more likely than not. People are not considering preponderance of the evidence anymore. They don't really care. They just think about, well, if they had given this person a second chance, or if they had given them a helper to help with some of these tasks, or if they had, helped them get to the doctor when they needed to, that might have changed the outcome. That's enough to justify a plaintiff verdict for some people. Next slide. These following are going to be some of the clips that support the idea that what we've heard is that jurors are really focused on what's fair. We can lay out in a verdict form all we want, was there wrongful termination? Was there retaliation? Was it based on race or age or religion? And jurors will say, I mean, it wasn't that exactly, but it was something else. So we'll just check the boxes that we need to in order to get to the place where we give money. Go ahead and play.
They weren't treated very fairly, but not illegally.
And I thought that they treated them unfairly. It seems like when they pushed, the company pushed back.
Yeah. I just think the company has some wrongdoing and they're due some money. Do I think they were fired directly for these two things? Maybe not, maybe some underlying things, but ultimately they did not agree, but I believe they are due something.
I think there was some like a wrongful termination, but it wasn't for the reasons that they declared. I feel like that termination is more of a, we need to cover ourselves and have some sacrificial lambs.
Maybe you would agree that regardless of the fact that the defense does not have a burden of proof, you as a juror would expect the defense to give you an alternate explanation for what caused this. 1, 2, 3, 4, 5, 6, 7, 8, and 9, 3 of you said no.
You got to give me something else, and that's just, maybe it's not according to the policy of law,
yeah.
But as a juror, if you need me to go against this maimed woman, you got to give me something.
And you know, some of these clips are obviously from our medical malpractice cases that we do. We just did one yesterday in Missouri where the same thing happened. This juror who on paper, she's a very conservative, older white woman, postgraduate degree, she looked amazing. Then she started saying, oh, to me, the burden's on the defense to prove their causation theory in this case. And the majority of jurors in the group agreed with her. So again, that's the new standard. It's not just for the employee to prove their case. It's about the employer's duty to prove that they did not just what was reasonable, but everything they could to help this person. Next slide.
Can I just stop right there for 1 minute, guys? And I think we're scaring the heck out of all of the audience because we're telling the truth. And in telling the truth, it's important to understand that there are ways to combat this issue of people not really paying attention to burdens of proof and not being completely wedded to burdens of proof. It just means you need to be thoughtful about how you present your evidence and how you manage the jurors' expectations. So you may go a little bit further in explaining why you did do what you did and why you couldn't have done some other alternative things. In the past, you wouldn't have bothered to talk about why you didn't do these alternative things because you'd say, well, it's not my burden of proof to show X, Y, or Z. But what we're trying to say to you is sometimes you need to anticipate that the jurors need a little bit more to understand why there are things that you didn't do and why it wouldn't have been reasonable to take certain additional actions that might have assisted the plaintiff. So don't be frightened by what we're saying. Be armed with the knowledge that there is a way to address this with your own evidence when you anticipate what it is they want to know. Does that make sense?
Yeah, and that's absolutely true. I mean, I think one of the most important things that we look at during our focus groups are areas of education. What are the things that the defense needs to get out at the very forefront from the outset and talk about as far as process, what is done, so that the jurors aren't just assuming the worst, they understand what our process is. You know, understanding what juror questions are going to be. So again, you can anticipate them and answer them and get in the position of, you know, explaining to the jury versus justifying to the jury. Another key difference that we've seen is the, you know, expectations are even more elevated, especially for big companies, to do more for their employees, to go above and beyond. It's not just about, you know, did you give them a paycheck? Did you show them you cared? And I mean, we're seeing that even with, you know, how our employees act toward us. I mean, they want, you know, lunches and ping pong tables and all of that, you know, at the workplace. And it's not just about, you know, coming in and doing their thing and going home. You know, that idea that, especially for long-term employees, if they're showing loyalty by staying at an employer for a long amount of time, then they need to have that loyalty shown back to them. This especially is true for our biggest companies that we work for, where there's expectations about policy and documentation, but also expectations to do more because you have resources. If you have lots and lots of stores or locations or whatever, you can find a place for someone who needs, say, an accommodation. Next slide. And these are some clips showing that. And before we show that, I want to say too, this one that you see, where you see the back of my head, this was actually a mock trial for a different firm in another employment case in LA. There's a reason we typically don't advise doing mock trials, at least as the first phase of research. There were a lot of people, because mock trials, we just start out with lawyer presentations. Focus groups, we talk about personal experiences and can weed out some people. There were a lot of people in this mock trial who hated corporations with such a passion and had such a negative opinion, they admitted they were biased. There were also some self-employed company owners who would never have made it on a jury either. So we could have pared down some of those people in a focus group, but they did make for some really good comments for these. Go ahead and play, please.
Someone that's been with the company that long, you try to retain them insofar as offer another position.
Cared more about the company, and the company didn't care about them at all.
It just lends to the idea of these companies that they just treat people, you're a number, you're not even, you know, where's the relationship?
As human to human, could have helped them out a little bit more.
Next slide.
Someone that's been with the company.
What we've also seen, and we've covered this to some extent, it goes back to that idea that people think the system is broken. People also think a big verdict is the mechanism to fix that broken system. Again, oftentimes is not about whether they like a certain plaintiff or even believe in the the validity of their case. It's about whether they think a company needs to be sent a message, or lots of companies need to be sent a message to get their attention and affect change. And so even sometimes when there's no actual punitive claim, we've seen jurors more and more inclined to build whatever number they think should be given into whatever blanks they're given on the verdict form. Next slide.
So I think building on what Claire just said, there are three things that I've seen that drive these really huge verdicts. One is this notion that they need to punish corporate indifference, that somehow something about your presentation or the manager's presentation of testimony suggests that the company was indifferent to the pain and suffering of this particular sympathetic plaintiff. And so I've seen big verdicts in an attempt to, quote, punish the indifference, send a message, get their attention by a big verdict. Another reason that I've seen big verdicts, just so you know, is that there's this notion that there weren't enough checks and balances on some rogue mid-level manager. Like, your company could be doing everything right. You could trot out your training and your policies and your, progressive discipline, but you may have some nasty, toxic, rogue middle manager who somehow, you didn't control. And there's a message that you need better checks and balances to control these kinds of people. So I've seen it in that regard. And somehow, if the manager or the witnesses come off as unemotional, or as Claire said earlier, somehow not sympathetic to the injuries of this plaintiff, we will see zeros being added to the verdict in an effort to sort of punish the company. And I think Dawn and I were talking about earlier that where we've seen this quite often is with mental distress claims, claims by someone who has significant emotional distress that they can support with medicals, and they're basically in bed with a cover over their head for 2 years after the termination. And people, if they are sympathetic and they are credible, will want to punish someone for that. And unless you can sort of put forth explanation and be somewhat sympathetic, gone are the days when a nasty cross-examination of a sympathetic plaintiff will help you. In fact, in some ways, that may just get you a larger verdict. Claire?
Yeah, next slide, please. And these are some good clips that show about jurors looking for fault in the system. Go ahead and play.
Number one, I think the food court manager was trying to cover this up.
Okay, what makes you say that?
Because number one, she had not reported to her boss.
Something's going on in that department, period.
They didn't document anything.
The manager's telling her not to add the assault or lawsuit or, whatever, sexual harassment in, because she don't want to probably do the paperwork.
When Ms. Gold talked to Mr. Hall, how come there wasn't a paper trail? Even to protect themselves. It's negligent on their part. They didn't necessarily take all the right steps.
The defense is going to say the lack of notes was a simple mistake. Crossed wires, basically, between the assistant general manager and the general manager. How many of you think that the reason for there being no notes either shows incompetence or shows there was some kind of cover-up? How many of you believe that at this point? 1, 2, 3,
Both.
4, 5, 6, 7.
There should be a mandatory procedure when it comes to any kind of complaint employee against employee or whatever. You know what I mean? There should be mandatory procedure that's followed, and obviously doesn't know that or doesn't follow the procedure.
Okay.
I believe didn't know that has got to have all kind of manuals, from employee manuals to procedure manuals.
Is it just because it's a company of that size, you just figure they have that?
They gotta have that.
Next slide.
Number one.
This has been touched on a little bit too, about how trust again overall has eroded, but COVID has really eroded trust in healthcare providers. And also what this means for employers is it also means people don't trust when we talk about COVID as a reason for layoffs or terminating someone. A lot of people don't believe that's accurate. Next slide. all these statistics show there's a lot more people than you may think that believe that COVID was intentionally planned. They have very negative feelings about vaccines. I mean, 1 in 5 people think they definitely or probably contain tracking chips. And so, again, what these numbers show is there's a significant part of your jury pool. And again, it does vary geographically too, but there is a big part of your jury pool that's not going to trust when you start talking about COVID as a reason for something. Next slide. These are some of the clips from people who, in cases where we've tried to justify layoffs because of COVID and jurors just aren't buying it. Play.
So companies that fire people use in some cases, use the COVID as an excuse to fire people.
But it's been there 20 years. Doesn't make sense to me over COVID. Like, it doesn't make sense.
The world changed once COVID started. Everybody lost their jobs.
One thing that can't be denied is that businesses took a big hit, whether you agree with it or not.
Sure.
So if you have to cut or, get rid of the fat just to keep the doors open, I mean, people had to make those decisions.
COVID didn't we were locked in for a while, but then they started to let the businesses open and you could have something delivered.
Words out that supposedly if you went to the hospital with COVID, hospitals would get more money.
I think it was blown out of proportion. Okay. Majorly. By
healthcare workers or by political?
Media, healthcare workers, the healthcare department, the whole industry. Okay. I think they way overreacted. They didn't do the proper research on it, and it's already been proven that a lot of it was false leading.
Yes, COVID affected a lot of industries, but healthcare and pharmaceuticals as a whole within the stock market industry and had their profits grow by over 27% on an industry-wide level. So it'd be really unusual that one of the largest healthcare industries in our area would be massively negatively impacted to the point of needing to lay off massive amounts of employees.
And, people cite statistics all the time. I have no idea where he got that 27%. I guarantee he made it up. But you know what? He was an authority in that focus group. Next slide.
So I want to talk here about a recent mock that we did in a discrimination case, and that were the mock jurors spoke to some of the same themes that we've been discussing this morning. So one quote was, 10 years and all of a sudden her manner of working there is not acceptable. It makes me think there was some discrimination. And I think what that really highlights is the need, particularly for long tenured employees, to explain really clearly what did change, right? That if the person has been successfully there for 10 years and then all of a sudden there's a turn in the story and now they're not performing adequately, what did change? So maybe it's a new supervisor who's going to enforce the rules. Maybe it's a huge error that the person made that caused a lot of strife at the company. But really kind of explaining that so the jurors can see a through line as to how the person was performing acceptably, at least for a certain point, and then things changed. Also, this particular focus group was very, very focused on warnings, or what they perceived as a lack of warnings. So one juror said, were there informal warnings before? Were there any resources offered to help her? What help was offered? Any resources provided or advice? Why were there no warnings? And again, even if there weren't, sometimes when we get a record, it doesn't have the perfect written warnings, right? That just didn't happen. But a lot of times we can show that the plaintiff did have feedback in some form that where they knew that they had to improve their performance. So maybe that's in in emails, maybe that's in one-on-ones, and we can sort of build a record of how they did get feedback and ability, the ability to make improvements in their performance. Another theme that came out in this focus group is the jurors' sort of perennial skepticism of HR. That often some of our key witnesses are people who are in human resources who are interacting with the plaintiff. But jurors bring a whole lot of skepticism from their own life experience, right? Almost every juror has interacted with HR in some form in his or her career. In this case, one of the quotes from the mock jury was, HR is part of the company. They are not neutral. They are more in line with the company. And so, you know, trying to sort of, to the extent you have HR representatives as witnesses, humanizing them and having the jury kind of understand how they were trying to help, what their role is, you know, how they are, you know, trying to help the employee. Of course, they do work for the employer, but they're trying to facilitate the employee, to give them more chances, to explain what's happening to the employee. And then, you know, finally, and we've touched on this a bit today, but one of the mock jurors said, quote, "I wish there was a claim for a crappy work environment," unquote. You know, so they kept referring to this particular workplace as chaotic. That sort of became like the word of the day. And, you know, they wished that there was a claim for that. And, you know, as Claire said, sometimes what that means is that they will, you know, just look for, what boxes do I have to check? You know, I don't like the work environment, so what boxes do I have to check so that the plaintiff gets some money? And so it really comes back to sort of personalizing your witnesses to try to show that you know, this was a fair workplace, and that the managers and coworkers were people who cared and who tried, and you know, getting away from just the literal elements of the claims, but trying to explain why this was a fair, the way that the company acted and its people acted was fair. Next slide.
So I'm just going to cover this very quickly. I mean, I could spend a whole hour alone talking about damages, but you know, there's just essentially an immunity toward big numbers because of the numbers that people are seeing. It's not just also athlete salaries anymore. Again, people are seeing actual verdicts, Trump, for example, that are in, you know, the hundreds of millions of dollars. And so they're looking at that as an example of what to do. Next slide. And we can skip this just for time purposes, because I do want to cover what's next. Basically, that's a bunch of people awarding a whole bunch of money. So what can you do? Strategies. You know, jury selection, the one thing that we've noticed during the past 3.5 years is how inconsistent it is. Even within a courthouse, different judges are still doing things differently. One thing that I have noticed overall is that it tends to be much more truncated than it used to be. We're getting less time to talk to jurors. That's why it's so incredibly important. If you have the opportunity to do a questionnaire and potentially ferret out some of those negative opinions privately and beforehand, that's fantastic. Also, the importance of social media audits. There are many projects we work on where we don't even go help, you know, in the courtroom. We're just doing social media audits from afar and sending those to counsel because we're really good at that. I'm a great stalker. But it means that we're able to look at people's Facebook and things, because people lie. That guy in the bottom right corner, he was one of our focus group participants. We have a pretty low bar. The only thing is that people can't be a convicted felon. This guy seemed weird. I looked him up. He was a convicted felon. So that's the thing. People will lie, whether it's to be in a focus group or to be on a jury. And you need to be prepared to spend the resources to figure out what's really going on with them besides what they're willing to disclose in a courtroom setting. Next slide. The one thing to take away from this, the best defense jurors we found in our focus groups are COVID vaccinated Trump voters. So you can look at that however you like. This is not a political presentation, but that is what we found statistically. Next slide. But I want to talk about just briefly about Trump jurors. What does that mean? I had the opportunity to see a plaintiff jury consultant's presentation that's like the mirror of mine, and he was vehemently recommending what he calls tribal jurors. He actually used that picture, so I stole it from him. But these are the people that the plaintiff's bar is looking for. They're looking for active conspiracy theorists who are angry at corporations. So we obviously want to be looking for the opposite of that. It used to be that we wanted conservative people, but that spectrum has become so wide. You also don't want someone who's so conservative they're going to polarize everyone else on the jury. Again, those are things you can figure out through social media. Next slide. I think we only have a minute left anyway.
Lynn, I think this one is you.
I got you. Thank you. So before we go on, I just wanted to give everyone the CLE code for today, which is 6478. Seyfarth Shaw, SS 6478. I just wanted to jump a moment on top of what Claire was saying about jurors and trying to ferret out those who are going to be sort of conspiracy theorists, anti-institution, anti-corporate people. And I think we can all agree that it's not always obvious to the naked eye. They're not wearing face paint. They don't have, hair down to their knees. It may be someone who is a housewife from middle America, but who also has bought into the whole conspiracy theory notion. And so you can't necessarily know just by looking at someone. So I do think, to talk a little bit about what Claire did, it makes a lot of sense to incorporate social media audits into your view. And that's because they may not say things in public, but in that echo chamber that is social media, if they've got a public presence, quite often those folks are being very open and honest about their views, anti-corporate, anti-institution, conspiracy theories, and that's where you're going to find that stuff. And so I really would recommend to spend the money to get folks to help you look into folks' social media background. I'd also design a few voir dire questions, which are designed to elicit reactions from conspiracy theorists. And what I found is using the word hiding something quite often elicits one response or the other. And by that, I mean questions like, are you someone who thinks that the government is hiding things from the public? And you get all kinds of answers to that. Often you can say, do you believe that executives in corporate America are hiding things from employees? Something about the word hiding, to me, when I've used that in voir dire questions, elicits all kinds of answers that you sort of go, and the key in this instance is to try to elicit a for-cause response. And by that I mean, when we go into trial, we have an unlimited number of for-cause challenges to jurors. And that means if you can show that this person would be biased or prejudiced and not come to the table with a neutral view of the case, you can get rid of them. It's an unlimited number of those folks. And if you have to use your very limited number of peremptory challenges, which may only be 3, use it if you have to, but do your very best to elicit a response that would allow you to use one of your unlimited for-cause challenges. And I think the word hiding works for me almost always. And I will also say that we had a mock trial in New York City, Dawn and I once, and there were 4 different panels. They all heard the same witness testimony. They all saw the same documents. But there was one guy on one panel that hijacked his panel. He was a conspiracy theorist. And we got a bunch of defense verdicts. But on this panel, not only did we get a plaintiff's verdict, but they all started to add zeros. And the more this guy talked, the more zeros they added for the defendant. So if you can root out these conspiracy anti-corporate folks, it is the best thing that you can do for your juries. Dawn, you want to wrap us up?
Yeah, I think we're at time, or actually a little bit over. Next slide, please. So just want to, next slide. Just thank everyone for being here. I know we did not get to all of the excellent questions in the chat, but feel free to email any of us, and we will try to follow up by email to the extent we can. Those are our email addresses right there. And thank you everyone for attending.
Thank you.
Thanks, everybody.